Hi, my name is Rachel with RDP Real Estate and More, and today I am going to be sharing about how my family lost 100 acres. Yes, my family lost 100 acres. This is part 2. There is a part 1, so if you haven't seen part 1, I recommend taking a look at part 1. Also, in this video, I am going to be sharing how it was done. I'm going to be reading from the document that was used in order to take the property. And this is for educational purposes. This is not legal advice, nor is this professional advice. If you need either services, I recommend consulting a professional. So we're going to get right into it. I'm going to pick up where I left off with part 1. Okay, my cousin had told us about the land was no longer our property, Heir property. And so we were, wanting to know what happened. And as I've shared, my great aunt is the one who took the property. So I told my mom, I was like, we have to go and find out exactly what was done in order for her to take the property. And so my mom was on board because being in the real estate industry, I understand you have to see it in black and white. You have to see the documents. So I recommend anybody take a look at the documents. So it was me, my mom, my aunt who was paying taxes in cash to my great uncle and then my great aunt and one of her daughters. So we went down to Southeast Texas and we went to the county clerk's office. And there was this lady that was there who really helped us. She printed out a lot of documents because I asked, give me all of the documents that you have for this property. And yes, we ended up with a bill, but nevertheless. So as I am getting these documents that are being printed out, I'm reading this information. My mom's standing right by me and we're looking at the information that is being printed out. And so as I am looking at the information, I am noticing what actually has taken place. And so how she ended up taking the property was through adverse possession. Yes, adverse possession. So I know that you have heard of adverse possession, and you may have heard of squatters, which they use it interchangeably. And so you're probably wondering like, well, how could your great aunt take this through adverse possession? Thought the same thing. But as I began to read the document, which I'm going to start reading the documents, and you may want to, make a mental note or take some notes, because basically I am sharing this because I hate that this happened to my family, and I would hate for this to happen to any other family. So anything that you can learn from our situation, by all means, learn. Okay, so the first thing that I'm going to read from the actual petition information is from and before 1965 into the present date, the plaintiff has resided on said property and has openly, continuously, and adversely occupied said property to the exclusion of all others, and has by said adverse possession continually claimed the 100 acres of land as her own to the exclusion of all others, and has paid taxes on the entire 100 acres of land each and every year except for 2001 and 1999, when the taxes had already been paid by the time that she went to the tax offices to pay the taxes. So the main thing, hopefully you got out of the situation as to the things that they're pointing out in this petition is continually. Okay. Now, she did live on the property continually. She lived on the property. Of course, she was my uncle's second wife. He lived on the property, as I've stated in part 1. She lived on the property. So that part was true. Now, in regards to the only times that taxes were paid were 2001 and 1999, that wasn't true. But as I've said, paying in cash is never the way. You should always have some type of account with the tax office showing your name, meaning if you are coming in with someone to pay taxes on Heir land, make sure you mail your portion in or go pay your portion in person, and that they have your name logged as well as a person who is also paying taxes. Okay, so that's part of it. Also, it says in the petition, the plaintiff makes no claim as a result of any interest that her husband may have ever had in the property. Her claim is asserted in her own right. Okay, I know y'all probably understand this, but I just want to break it down myself. She's saying that I'm taking the property not because I was married to him. I'm taking the property in my own right. Okay. Also, it goes on to say, the plaintiff has introduced evidence to show the court that the proper parties are before the court. The evidence is uncontroverted that the deed omitted into evidence as Exhibit 4 conveyed the entire 100 acres of land to my great-grandfather. The evidence is uncontroverted that my great-grandfather died intestate. As I've shared, yes, they could not refute that there was a deed on record from my great-grandfather because, of course, I told you the land had passed down. And so I even have a copy of the deed to the property. So that couldn't be refuted. So they had to address it. Also, it says that although there is some testimony to show that the plaintiff's deceased husband was a son of my great-grandfather, and some testimony that my great-grandfather had additional children, there is insufficient evidence before the court to allow the court to enter a finding as to who would have inherited the property. That's what they said. Wasn't enough evidence. Now, the issue that I have is that, of course, we were around the property. My aunt and my uncle, they love that property. They were at that property all the time. My uncle was almost there every weekend. So yes, they were there on the property. They were helping to maintain, especially on the end that was considered our portion of the 100 acres. So yes, there was someone always around in my family outside of her living on the property because my uncle was the last living sibling of my grandmother's sibling, and he was living on the property, as I mentioned in part 1. Of course, when he passed, she was staying there. Yes, we could have told her to leave, but we didn't. We basically allowed her to remain. That's how she ended up getting the cash tax money to go in on the taxes. We allowed her to stay, which we could have basically, went against that and had her to leave, So we didn't do that though. And so that was correct. She was staying on the property, but what wasn't correct is there was nobody else coming to the property or doing anything on the property. That wasn't true. That was false information. And so it goes on. Although there was some evidence that for a period of time, other family members lived on the property, there is no evidence that any of these defendants claimed the land during that time. She knew that it was our family's land. There was no question about that. They knew how to contact us, meaning my great aunt, who was married into the family, not a bloodline heir, knew because she was really good relationship with my aunt who was paying her taxes in cash. They were close. And my uncle, he was really close around her too when he was living. And so her daughters kept in contact with my mom. They knew how to get in contact with us, even if she was going to do this thing as far as taking the property. And even though somebody may say, well, how do you really know that they paid her cash? Despite that part, the part of she knew where we were and did not basically let us know that she was going to try to take the property. That is one of the things that really, I guess, hurt, the betrayal and the lies. Okay. Also, it says, but more importantly, the uncontroverted testimony was that no one else used the land since at least 1965, some 47 years. Now, I'm not going to tell my age. However, I'm old enough to say that I was even at the property before. My uncle has a trailer which is still there with the old house that they lived in. We had a barbecue at that trailer. The great aunt who was married in that took the property, she had some type of gathering more than once, but she had some type of gathering on her end where my great uncle was. But anyway, that wasn't true in regards to nobody, in that we wasn't interested in the land. She knew that it was our land, point blank. Okay, it also goes on to say this is a case where an elderly lady has resided on the property in question and made it her home for virtually her entire life. And I want to stop there. Some of y'all think that these seniors don't have enough in them to do certain things. A good attorney would give them enough. Don't underestimate just because someone is an elderly person. I'm going to leave that right there. She alone has been responsible for the upkeep of the property and the payment of taxes for all these years. She alone has enjoyed the fruits of the land, however humble they might have been. So, it is there an equity. If there is any equity, it cannot lie with the defendants who have never used the property or, for that matter, made any claim to the property. So, the thing is, it was a situation where, lies. Lies. That's all I can say is lies. Somebody may say, well, why y'all didn't try to get the property back? There was an attempt that I'm not going to go off into. Ultimately, we lost the property. My mom, my side didn't go in to try to get the property back. We don't have any ties to the 100 acres at this point. Me and my mom, we don't, have anything to do with it. The Heir property, as we knew it, is gone. And so hopefully this information that I've shared can help someone else to safeguard their property. I also want to basically provide the information that you can look up adverse possession, the law. And that's Texas Civil Practice and Remedies Code. Sections 16.024 and 16.030. I recommend taking a look at the adverse possession laws if you are an heir, and just getting acquainted with it so that you can know what not to do. And I am concluding this video. I hope that you will look at the other videos in which I post. I'm asking for you to like and subscribe, and I hope that you have a fabulous day.